Hello and welcome to our webinar, Navigating the Complex Web of Medical Leave Laws. My name is Julie Dorr and I'll be your moderator for today. I wanted to first start off by letting you know that the handout that many of you have been emailing me about right now is actually available now in the webinar. It's in the handout section. Just simply download it. It's actually a copy of the presentation from today. So go ahead and do that right now. And then also I want to let you know the presentation is going to last about 40 minutes. And we'll still have time at the end for your questions. If you'd like, you can start asking questions right away by putting them in the question section. Just type it in and send it there, and then we'll hold it, put it in a little holding pattern at the end of the webinar, and we'll ask those aloud so that our panel can answer them for you. Before we get started, though, please note that this webinar and all of the accompanying materials are protected by copyright and that the entire conference is being recorded. This presentation provides general information only and does not constitute legal advice. We recommend that you consult with your legal counsel to address any of your specific situations. So let's get started today by welcoming our expert panel. First, we have attorney Marla Merritt-Robinson. Marla's with the law firm Merritt-Robinson, Jackson & Clarkson, where she's a partner and head of the firm's transactional department. She primarily practices in the areas of corporate, mergers and acquisition, real estate, finance, and employment law. And then, of course, we have Linda Duffy, who's the president of Ethos Human Capital Solutions. Linda works with business owners and executives to provide strategic human resources direction, develop leadership talent, mentor those leaders, and also increase organizational effectiveness. Linda's going to start us off today. So, Linda, let's get talking about this topic.
Thanks so much, Julie, and welcome everybody. Thanks for joining us today. I can tell just by the number of attendees that this is a hot topic for everybody, so hopefully Marla and I can provide you with some excellent advice and some guidance on how to manage leaves of absence in your companies. Today we're going to be focused specifically on medical leaves of absence. As everybody knows, in California there's about another, 17 or something you have to comply with, and those we will actually address next month. So if you're interested in the other types of leaves having to do with, taking your kids to school or bone marrow donation or anything like that, we'll get to those next month. Okay? So today we're going to be focused on family medical leave, California Family Rights Act leave, pregnancy disability, and then Marla's going to be talking about American with Disabilities Act and FEHA and some of those regulations, and then also workers' comp leave. So hopefully those are the big ones that everybody's going to be concerned about. Now, when we were trying to figure out what's the best way to explain all of this very complex information to everybody, because this is really detailed, first of all, I'll just let you know up front that we're going to try to stay out of the weeds to a certain extent because there's a lot of nuances, right? But what we try to do is compare all the leaves using some standard criteria, and that's what I put up on this slide. So our thought process is, okay, first of all, let's look at, is the company required to provide this particular leave? So we'll talk about the companies that are covered by each of the leaves. Is the employee eligible? Because the company may be covered, but the employee may not be eligible based on service requirements or the qualifying events. How much leave must the company provide, which is a sticky one, especially, this is why Marla's talking about this, under the ADA and FEHA. So how much leave must the company provide? And then must I reinstate the employee? Do I have to put them back in a job or their job after they come back? Does the employee have to give me some notice? And then can the company force the employee to use vacation or sick? So we're going to talk about that. And then finally, how does it affect the employee benefits? So there'll be some a little bit more detail in there as we go through, but that's sort of the general framework that we came up with for dealing with these. So starting with the Family Medical Leave Act, everybody knows this is the federal law that allows employees to take medical leave for the qualifying events that you see there. Let's start with the covered employers. So covered employers would be any employer that has 50 or more employees in a 75-mile radius. Now, again, our comments are going to be specifically related today to private employers. So if it is, if you work for the County of Orange or something like that, you're going to be covered. But we're talking specifically about private employers, so 50 or more employees in a 75-mile radius. Now, again, I'm going to tell you there are some definitions for how you define employees that are just too detailed to get into today. So if you're right on the border, if you have, 48 employees, but 2 weeks ago you had 52 employees, and you're wondering if you fall under this or not, then take it offline with us, and we'll be happy to help you get that definition of how you actually count the employees. So 50 or more employees in a 75-mile radius. Okay. Then you look for, okay, so I have 55 employees, let's say, in a 75-mile radius. The employee comes to me and says, I need to take a leave of absence because I'm going to have a baby or whatever the case is. Then you say, okay, is the employee eligible? So the employee under FMLA has to satisfy 3 standards, all 3 standards, okay? So they have to have worked 1,250 hours of service in the 12 months prior to the leave. They also have to have been with the company for 12 months. Okay, so you may satisfy that first one, in the first half of a year, but you will not satisfy the second one until you've been there actually 12 months of service. And then the third one can get a little tricky, but you have to work at a facility with 50 or more employees or within 75-mile radius of 50 or more employees. The other thing to note is there is some language around home workers and looking at where they report. So let's take an example of, let's say we have a salesperson. They work in Nebraska, but they report into California. If they're working out of their home in Nebraska, but they report into a sales manager here in California, they're going to be counted as though they're working in California. And if there's 50 or more employees here, then they're going to be eligible, even though they may not have any other employees within a 75-mile radius. Let's say, however, they work in a small sales office where there's only 4 employees, but they're reporting to that sales office in Nebraska. In that case, if there's only 4 employees in a 75-mile radius, they would not be eligible under this. So if you have remote salespeople in particular, but anybody that's working sort of in a one-off situation, you want to take a look and figure out where they're actually reporting and then use that head count. So the qualifying events are pretty straightforward. FMLA is a little bit different from the other ones in that there's the specific coverage for military family leave that we don't see under CFRA, for example. But for birth of a child, placement of child for adoption or foster care, if you're caring for yourself or a family member, child, spouse, parent with a serious health condition, then you're covered there, and then the military leave. Now the length of leave available is up to 12 weeks in a 12-month period. Okay, and that can be taken intermittently, and then if it's to care for a service member, it's actually a lot longer. It's 26 weeks, so 6 months during the year. Now, that 12-month, or that 12 weeks in a 12-month period, that 12-month period can be calculated using about 4 different methods. So you could have a fixed 12-month leave year, like you could say it's the fiscal year, or on the employee's service anniversary each year, and that's the 12 months you're going to use. You could have it be a calendar year. You could have it be a 12-month period measured from when the FMLA is first taken, or you can do a rolling 12-month period measured backward from the date they use FMLA. So there's a lot of different ways that you can actually calculate that 12-month period. You just want to be consistent and make a decision about how you're going to count it. With FMLA, the job is protected, so if an employee goes on a leave of absence, you need to guarantee reinstatement to a same or comparable position. There will be some defenses for that, but you want to be really careful anytime you're thinking about not bringing them back into a job once they go on a leave of absence. That's when you need to pick up the phone and call legal counsel. Just pick up the phone, call Marla, and say, hey, how do you feel about this? There are some circumstances when you can refuse to reinstate a key employee, and there's actually a definition for key employee, as you can imagine, which has to do with a salaried employee who is one of the highest paid 10% of all employees within a 75 miles of the employer's work site. So if it's a key employee, you may not have to reinstate them, but again, we see so much litigation around leaves of absence these days that I would just encourage you to pick up the phone and check with legal counsel before you make any decision. And then, does the employee have to give you notice? Yes, 30 days notice if the leave of absence is foreseeable. Obviously, if somebody drives home on Friday night and gets into a car accident, they're not going to be able to give you 30-day notice, right? So if it's foreseeable, if it's not foreseeable, then they don't have to give you advance notice. Let's talk about what your requirements are for when you what notices you have to give to the employee. So you need to designate the leave of absence as FMLA leave within 5 days of request. So an employee comes to you, and it could be verbally or in writing. Employee comes to you and they say, hey, I need to take a leave of absence because I have a serious health condition. You need to go through and look at everything that's on this list here. So you need to go down your checklist and say, okay, are we covered employer? Yes. Okay, we have to give them a leave. Yes. Are they eligible? Do they meet those 3 criteria that we talked about? And if the answer is yes, then you want to give them a designation notice, which is just basically a letter, a memo, a form, whatever you want to create within 5 days of the request, and it has to contain this information. So you want to make sure that you specifically tell them that you're going to count their time against their FMLA available time, and how much of that will be counted. If you don't know, like if you don't know how long they're being gone, that's fine. Then you can update that periodically, but you need to let them know, okay, so if you're going to be gone from, February 1st until March 1st, we're going to count 29 days against your 12-week leave. You want to also tell them whether or not it's going to be, if you're going to require them to use any sort of pay, and we'll talk about the rules for that in a second, or if they can, or if you're going to require 2 separate things. And then if you're going to require them to have a fitness for duty certification when they come back to work. And of course, we always encourage you to get that, some sort of doctor's release saying that the person's able to do the job, and if so, you're going to want to give them a list of essential job functions so they can provide that to a doctor to get an opinion. So I just sort of tell my clients, you want to give them a letter that sort of spells out their rights and their responsibilities. So are they going to be put back into a similar job? Are you requiring them, for example, to pay for their part of insurance while they're on a leave of absence? What happens to their insurance? So let's take a look at some of the benefit-related stuff. So can an employer require the use of sick and vacation? And so the answer gets a little confusing. This is how I sort of think about it, is on vacation, you can require somebody to use vacation if it's not for their own medical condition. So if they're taking FMLA leave, then you have to look at what type, why they're taking the leave. So if they're taking the leave to care for somebody else, if they're that's pretty much the only one, I guess. If they're taking a leave to care for somebody else, you could require them to use vacation. You can require them to use sick if they're not also, I'm not being very articulate about this. Take a look. If it's for their own serious health condition, if it's for pregnancy or their own health condition, you can require them to use sick but not vacation, I guess is the best way to say it. So you've got to take a look at what the reason for the leave is. As far as the effect on benefits, each of these laws is going to have a slightly different answer for what you have to keep in place. For FMLA, you are required to continue the group health benefits as though the employee had never taken leave. So you want to take a look at that as well and make sure that you're allowing them to keep that in place. Now, there are requirements in terms of you can make them continue to pay the portion that normally would have come out of their check. There are specific notice provisions if they don't pay, so you want to make sure you look at that. You can't just go, oh, well, they didn't write us a check, we're going to cut off their insurance. Never do that. But you can tell them we're going to cover it for the period of your leave, but you still have to pay the, $100 that comes out of your check each week or something like that. And then if they fail to make those payments or make arrangements to make those payments with you, then you can go ahead and take them through the process. A couple other documents you want to be aware of for all of these leaves. Anytime somebody goes out on a leave of absence, and this is not in a slide, so I would just jot this down, you're also required to give them the notice to employee change in relationship form. So the form that you normally give people now when they terminate employment and they leave the company, there should be a box on there to check to say the person's leaving today. Essentially, that's how you think about it. They're leaving today based on a leave of absence, and so you're going to want to check that box. And then also you're going to give them the EDD pamphlet DE 2320, which is called For Your Benefit, which talks about disability and paid family leave and unemployment insurance. So you want to give them those 2 documents in addition to a document that you're going to give them designating the leave. In general, what you want to think about when you get to this type of analysis with regard to sick and vacation and effect on benefits is, again, what are their rights under the leave, and then what are their responsibilities on the leave. You also want to sort of separate 2 other things. Separate the time off from whether or not there's going to be pay. Because in some of these leaves, again, the person may qualify for paid family leave if they're going to take care of somebody else. They may qualify for state disability insurance if they have their own serious health condition. There's no requirement for you as an employer to pay for these leaves, but they may qualify for pay someplace else, or they may have vacation and sick time or PTO that they want to take, or you're going to require them to take. So first look at, does this person qualify for any time off? And then as a separate issue, is there any way that they're going to get money while they're off on their leave of absence? Okay, so let's look now at California Family Rights Act. So California Family Rights Act was sort of the California mirror to a certain extent of Family Medical Leave Act. There are some differences, and so where they're the same or substantially the same, we just made a note, same as FMLA. So again, 50 employees in a 75-mile radius, same three qualifying or same three eligibility requirements. Qualifying events are the same, except CFRA does not have the military family leave, and most notably, it specifically excludes pregnancy. And the reason for that is, you're going to see in a second, because we have our own pregnancy disability leave. So if under FMLA, a woman in California is going to qualify if she's pregnant or disabled due to pregnancy, she's going to qualify for FMLA, but technically in California she does not qualify for CFRA for pregnancy because it's specifically excluded under the law. The length of leave available is the same, but again, there's no leave of absence regarding service members, so forget the 26 weeks there. So we're just talking about the 12 weeks. It's still job protected, and they still have to give you notice if they know in advance if it's foreseeable and they know that they're going to be going out on their leave. Okay, so as far as what you're going to want to give them, whoops, sorry, we skipped over one. Hold on, there's a little bit of delay there. So what you're going to want to give them is, again, you're going to want to do the same thing, which is give them a written notice that designates that it's going to count against their CFRA allowance. Okay, so don't just say, yeah, we're going to go ahead and give you a leave of absence. You want to specifically say, we're going to give you a leave of absence under FMLA and CFRA, or under FMLA but not CFRA, or whatever happens. Okay. So you want to make sure that it's going to designate that. Excuse me. The other thing to note about the designation is, generally speaking, you need to, within however many days, 5 days in the case of these two, you want to give them the designation. Normally, you're not allowed to go back and retroactively designate it. And if they come back to work, if they go out on a leave, say for a week, you haven't even made your decision yet or whatever, maybe you don't have enough information, then they come back to work, you can't retroactively designate as FMLA or CFRA, generally speaking. But if they go out on a leave, or maybe they're out sick for a couple of weeks and you don't know yet, that you just think they have the flu, and then it turns out, no, they really have pneumonia, and the doctor says, oh, they're going to be out for the next month, or they have mono or something like that, and you didn't realize it at the beginning, and nobody told you, oh, it looks like this person's disabled and won't be able to work, then you can go back retroactively while they're still out and designate as FMLA and CFRA, but you're going to want to give them notice on that. Okay, everything else on this page I think is pretty self-explanatory, so we're going to move on to the next one. So the vacation and sick is essentially similar to the FMLA, and the effect on benefits is a little bit greater under CFRA. So you have to continue to provide group health benefits during the leave, just like you do under FMLA, but the California Family Rights Act actually is a broader coverage because it says that they're entitled to accrual of seniority. So a lot of times I'm used to writing, policies back in the days where if you're on a leave of absence, you're not going to accrue any sort of your seniority is going to stop essentially. And at this point, it just doesn't make any sense to me to even do that because it's just going to be a pain to sort of keep track of that. They're entitled to continue to accrue their seniority and to participate in all of these different benefit plans. So it's not just the group health benefits that FMLA covers, but now it expands beyond that to all the ones that you see listed here. Okay, I want to talk about pregnancy disability leave law. So this is specific to California, and in California, where the other ones are 50 or more employees in the 75-mile radius, you're covered in California with only 5 employees. So you can just have 5 employees. If someone comes in, they're pregnant, you're going to have to give them a leave off, okay? All employees with a pregnancy-related disability are eligible for this. So again, there's no service requirement, there's no number of employees in the area requirement, there's no number of hours like there are under FMLA and CFRA, It's just if they're a pregnancy-related disability, then they're going to qualify. But I want to break down that phrase a little bit. So pregnancy doesn't necessarily mean that the woman is carrying a baby. It could be due to miscarriage. It could be postpartum depression. She's already had the baby. So if the doctor says that she's disabled and it's related to pregnancy, there's going to be coverage under this law, most likely. Okay. Also, it has to be a disability. So women are pregnant for 9 months, generally speaking. They're not disabled the entire time, but they may have a disability, and it may be intermittent. If the doctor says, look, it's related to her pregnancy, and she cannot perform one or more essential job functions, she may be entitled to a leave of absence under this law. It could be severe morning sickness. It could be prenatal or postnatal care. It could be, oh, you need to be restricted to bed rest for a period of time. There could be so many different things. Pregnancy-induced hypertension. There's so many different things that could come up before, during, or after that pregnancy. So if there is something that's pregnancy-related, doctor says that she's disabled, can't perform one of the job functions, then you may be giving her time off, whether it's intermittent or for a long period of time. So the qualifying event is pregnancy-related disability preventing some, work in terms of one of the essential job functions. Now, the period or length of disability is up to 4 months or 17 1/3 weeks while she is disabled. I get calls all the time, or I have employees say, well, I'm going to take 4 months leave of absence when I have my baby. Okay? You're only entitled to up to 4 months for the period of disability. So for a normal pregnancy, that's generally going to be 4 weeks before and 6 weeks after the woman has the child. If there is a complication, she has a C-section, something like that, it could be longer. But for most normal pregnancies, it could be 10 weeks. Okay, so it's not 17 1/3 weeks automatically, and I get that question a lot, and I hear that mistake made a lot. So if somebody's going to somebody's coming in, you always go by what the doctor says. So the doctor says, okay, she needs to take a period of time off. You go with whatever the doctor says that period of time is, but it's for the period of disability when it comes to pregnancy disability leave law. Job protection. This one's really specific, guaranteed to the same position with very few isolated exceptions. So for example, let's say the company shuts down while she's on her pregnancy leave. Obviously, there's no job for her to come back to. Maybe her whole department gets, offshored or something like that. There's no job for her to come back to. There are going to be some exceptions, but again, anytime you have anybody on a medical leave of absence and you're thinking about doing something that will not place them back in their prior position, or in some instances with other leaves a comparable position, pick up the phone and call somebody and make sure that you're getting good legal advice on that. Notice requirement for the employee, same thing. Obviously, in the case of pregnancy, normally they would have notice that they're going to have a baby. Okay, responding to the request for pregnancy disability leave. You have 10 days to respond after the receipt of first request, but keep in mind that you may be running this concurrently with FMLA. So if there's a 5-day notification under FMLA, you probably are going to want to do the same thing, and just keep that in your head as the standard. Once the leave is approved, it can be retroactive to the first day of the leave, and there are additional notification requirements that you must give the employee. So there's a Notice A, you can just Google that, Notice A, California Pregnancy, and if you have less than 50 employees, you have to give that out, and Notice B if it's greater than 50 employees. On the question as to whether or not an employer can require the use of sick and vacation, yes to sick, because again it's a medical condition, no to vacation or PTO because it's not a medical condition. So you can have a policy that allows them to take it, and I have a lot of clients that will do that, because the last thing you want is for someone that has 3 or 4 weeks of vacation or PTO stockpiled to go out on a pregnancy leave and then come back and then say, hey, I'd like to be out next week on vacation, right? So a lot of people will say, hey, do you want it? And most people I know will take any pay they can get while they're out on their leave of absence, and so a lot of times that ends up being zeroed out, but you cannot force a vacation or PTO. And then on this one, this was sort of a new law that came out just, I think, 2 years ago, that you are required to continue group health benefits as though the employee had not taken leave at all. So you want to make sure that you're leaving that health care in place. And again, you can require them to pay their portion that normally would have. You just want to be really careful and not take away that, especially when it comes to PDL. Now, let's take a look at how these three laws interplay, and then I'm going to turn it over to Marla to talk about the rest of them. So I made a little chart here. Some of you have probably seen this before. Let's assume that the person's going to be completely disabled for the maximum amount of time, and there is due to pregnancy. So let's say the woman's going to need all 17 1/3 weeks due to pregnancy. You're actually going to designate the leave under FMLA and pregnancy disability leave law at the same time. So let's say she comes to you January 1st, or maybe, you know, the baby's due February 1st. She comes to you and says, I'm going to take the 4 weeks before, and then I'm going to be gone for some period of time afterwards, and you're going to designate both leaves to start. You're not going to designate it under CFRA because, remember, pregnancy is excluded under CFRA. So it would run concurrent under FMLA and pregnancy disability leave for the overlapping period of time. Once she has exhausted those, then CFRA could kick in for baby bonding. Okay, so she could, in theory, be gone her 17 1/3 weeks while she's disabled due to pregnancy, and then say, I want to take my 12 weeks now under CFRA so I can baby bond. Okay, so again, this won't normally happen, and I mean, this usually doesn't happen in a normal pregnancy, but you could have somebody out, you know, from January 1st until essentially the end of July-ish, if they're going out on a pregnancy leave and then they want to stay home and baby bond. Okay, so hopefully that is clear. And with that, I'm going to turn it over to Marla so she can talk to us about the ADA.
Thank you, Linda. I can't thank you enough for making such a complex area simplified, but I hope everybody still takes away that there are so many traps here for the unwary and for those of us who don't deal with it every single day. I mentioned to Linda when we were preparing for this webinar that in our office, all the lawyers that respond to calls on leave of absence are required to still pull out our books and charts that we use in order to respond, because there's just so many areas you have to look at. And here is another one. We're going to talk about the Americans with Disabilities Act. This is a federal statute that covers employers with 15 or more employees, and we're going to use the same structure of questions as Linda did. Eligible employees are all eligible employees with qualifying disabilities. Under this act, disability is defined as physical or mental impairment that substantially limits, and the key word here is substantially, a major life activity, a record of such impairment, or being regarded as having such an impairment. I can give you some examples of major life activity that can show you how simple it is to fall under this definition. Caring for oneself, walking, lifting, bending, seeing, hearing, speaking, breathing, sleeping, reproduction. As you can see, very broad. So all employees with a qualifying disability under that definition are eligible employees. What are they eligible for? They're eligible for time off as a form of reasonable accommodation. But not just time off. We're talking about leaves of absence here, so we're going to talk about that. But reasonable accommodations can be other things, so I'll give some examples later. But they are entitled to leave if that is a reasonable accommodation. If we go to the next slide, the length of the leave is not specified. Unlike FMLA and PDL and CFRA that Linda just went over, there's no set time. This is very unfortunate for employers. The need for the leave and the amount of time is based on what is a reasonable accommodation. The legal definition of a reasonable accommodation is any modification or adjustment in a job. It's an employment practice that allows the individual with the disability to enjoy the equal employment opportunity. So I'm going to give you some examples of accommodations: providing personal assistance or attendance, job restructuring, part-time or modified work schedules. There's a litany of them. But we're just talking about, because of the topic of this webinar, is leaves of absence. Is a leave of absence a reasonable accommodation? When we talk about reasonable accommodations, we have to always look at who we are as an employer, because certainly what is reasonable for Coca-Cola or Hewlett-Packard is not reasonable for MRJC law offices. We're much smaller. And the reasonable accommodation does not have to be provided if it's going to cause the employer an undue hardship. So we have the first battle of the word reasonable and two sides can argue forever over what is reasonable or not reasonable. So we have to contend with that. And then we have the second battle over what is an undue hardship. These are both terms that don't have set definitions that apply to all. Undue hardship, we do have some direction from the courts and some interpretations where we know that if it's unduly costly or extensive and substantial fundamental change in the business, that's an undue hardship. But again, you end up with more and more subjective terms of what's unduly costly. We know if it's costly, what is costly to me might not be the same as what is costly to someone who makes more money than me. And that same is true for the profits of an entity. So this is where the analysis really requires the assistance of an attorney, and many times we're having to opine that we can't tell you, it appears reasonable, and many employers err on the side of caution and give as much leave as they can. Notice required, ordinarily, yes. We'll get into that a little bit when we get into the interactive process. It's always, to the extent it can be, because it can't always. Sometimes the employee, a disability occurs and they can't give notice. So let's talk about the Fair Employment and Housing Act. ADA is the federal version of protection from disabilities. The Fair Employment and Housing Act is the California version. We always have to have our own set, just like FMLA and CFRA. Ours, of course, just like FMLA and CFRA, is much broader. And I should note that these two acts, these two statutes, are enforced by the EEOC and the DFEH, the Department of Fair Employment and Housing Administration. Both of those entities will take claims under either of these acts and share them with each other. That's just as an aside in case some of you have ever received these claims. So FEHA, the covered employers here is 5 or more employees. So you can see already it applies to a broader section of employers, not 15 like the ADA. Eligible employees, same as ADA, except, we should everybody write except next to their side there. The definition of disability, again, is much broader. It includes a perceived disability, where someone's regarded as or perceived as having a disability, but they may not, but they're perceived as having one, or perceived as having a potential one, or a special education disability. Additionally, if you recall under the ADA, the definition, it substantially limit a major life activity, and I gave you examples of major life activities. Under FEHA, the impairment only need limit, not substantially limit. We have cases that we've read that seem to imply that even the flu could be a disability under FEHA. Very frightening. It also protects FEHA itself against diagnosis or history of cancer and genetic characteristics and some specific medical conditions. So if somebody has a specific medical condition, you might want to check to see if it's covered. And then again, that's a qualifying event, same as the ADA. The length of the leave, we go back to the reasonable accommodation analysis. It's not specified, unfortunately. It would be much simpler for all of us employers if it was. And is the job protected? Yes, same, to be put back in the same or similar comparable job. The notice requirement. Ordinarily, yes, but in this case, it's done sometimes by the employer. If the employer perceives that there is a disability or gets notice of information that indicates a disability, the employer must start that notice period, and I'll talk about that more when we get to the interactive process. Some examples of the interplay between the ADA and the FMLA. Some FMLA serious health conditions may also be ADA disabilities. The examples here are cancers and serious strokes. The serious health condition may result in exhaustion of FMLA, but then once you've exhausted that FMLA or CFRA, then the ADA and or the FEHA, usually FEHA because it's broader, will kick in, and then you have to start the reasonable accommodation analysis. In California, we almost always look to the FEHA because it is so much broader than the ADA. Excuse me, I'm like Linda, suffering from a little bit of a tickle in my throat. So let's talk about the dreaded workers' compensation leave. And I say dreaded only because I know workers' compensation is dreaded by all employers. I'm not a workers' compensation attorney, although there is a portion of workers' compensation leave law that and discrimination from disability, the disability discrimination prohibitions that applies here, which is why we've included it. So covered employers are all employers. Unless you're self-employed, in which workers' comp doesn't apply to you, and you're the only one, if you have one other employee, it applies to you. Eligible employees. All employees with a work-related disability are eligible for leave under workers' compensation leave. Qualifying events. A work-related disability preventing work. Any injury is going to potentially be a qualifying event leading to leave. Length of leave. Again, unfortunately, not specified in the law. I can tell you we have a matter in our office that we're handling the limited area that's not part of the workers' comp claim, but the 132A we're going to talk about in a minute, that has been going on for over 15 years. So this person has been on leave for that long. And I'm aware of others that have been even longer. So it's very unfortunate that there's no term limit in the statute as to how long the length of leave can be. Is the job protected? Yes, subject to business realities, exceptions, and I would point out with all of these that if the individual was going to be terminated anyways before or during, based on like a layoff or a corporate restructuring, that termination is not going to be in violation of any of these statutes. It's just going to give rise immediately to a claim that it is in violation of the statute. Then the burden is on the employer to prove otherwise, that the employee was always going to be terminated in any event. Very high burden, and a lot of employers choose not to take that risk. Notice required. Yes, the employer is required to give the workers' comp claim form to the employee as soon as the employer suspects there might be a workers' comp injury. I unfortunately have this experience with clients all the time where they say an employee left feeling sick, saying that they were stressed out from work. That is being put on notice by the employee to the employer that an injury may have occurred at work. That stress arose from work. Now, my employers will often say, well, you don't understand, this employee's going through a divorce, she's got an illness, she's pregnant. These are other things that are causing stress. It doesn't matter. If an employee says anything or does anything, or someone else at the employment gives the employer an indication that there may be an injury at work, you must give the claim form. Now, that doesn't mean the employer won't be allowed to defend the claim. It just means you need to give the employee the claim form. It also doesn't mean the employee has to fill it out and bring a workers' comp claim. Many times they don't. But you are required to give that claim form to them so that they can complete it and file it timely. So there's a requirement, a time requirement on the employer side and a time requirement on the employer to give and the employee to file. Can the employer require use of sick and vacation? This is very tricky and one of those ones you really have to write out if you've got someone who's eligible for FMLA. If they're eligible for FMLA, you cannot require the employee to use vacation, sick pay, or PTO during the FMLA leave that runs concurrently with the workers' comp. So if they're going together. However, the employee can use accrued benefits to supplement workers' comp if both of you agree. So if the employer says it's okay, then it's okay. If the employee wants to, though, you can't require. If the employee is not covered by FMLA or the employer is not covered by the FMLA, you can require the employee use any paid off, any paid time off during any absences due to the work-related injury. If you do want to do this, you need make sure, both in this instance and the ones that Linda spoke about, where if you want to, in the few cases where you can, make an employee take paid time off, be sure to put it in your handbook, be sure to put it in your employment agreement with that employee. This does not apply to sick, the new mandatory sick leave. We really don't have final guidelines on that. This is prior to that, and the new sick leave did not carve it out. So we're hoping that it's going to be the same, but we don't know that for sure. And so responding to workers' compensation leave requests. Failure to provide the request will automatically result in what's called a Labor Code Section 132A petition. Labor Code Section 132A prohibits the discharge or the threatening of discharge or any discriminatory practice against an employee who has filed a workers' comp claim or who has threatened to file a workers' comp claim. You cannot take any adverse action at all. And once you have done so, the employee has the right to file what's called a petition in the Workers' Compensation Appeals Board with their claim alleging a violation of 132A. That petition is about 2 pages long. If they already have a workers' comp attorney, they're going to take advantage of filing that because it doesn't take any effort or cost whatsoever. They also have the right, as we found out with a recent case last year, to file in Superior Court for wrongful termination under public policy. So they can choose to go that route as well, which is a little more time-consuming, has a little higher filing fee. We don't see that as often, but they certainly have that right, and it's much more exposure for the employer because the potential damages could be higher. The Labor Code 132A can result in reinstatement, back wages, and penalties up to $10,000. The worst part about it is there's no insurance for it unless you have EPLI insurance, Employment Practices Liability Insurance. In other words, it's not covered under your workers' comp policy, like the workers' compensation claim that you may be fighting, or even agreeing to if it's being covered in the workers' comp board arena where these matters are. This, whether it's in the workers' comp arena or it goes to Superior Court, is not covered by that workers' comp insurance. So it's very expensive for employers. Now, as a practical matter, I will tell you that most of them settle with the workers' comp claims. We always advise the employer that we will send a letter to their carrier representing them in the workers' comp claim, asking them not to settle, especially if it's a dispute at all, the underlying workers' comp claim without also settling the 132A matter. And most of the time, nearly all of the time I should say, that happens. Occasionally the employer will have to throw in some de minimis amount of money. I have not had any of them go to trial in the 27, 28 years I've been practicing. That doesn't mean they don't, they do. We've just been very fortunate that they have not. And then again, responding to the leave request, if you haven't already, you want to make sure you give them the claim form to fill out to make the workers' compensation claim. Even if you don't agree with a claim, or if you just think there might be an injury, you need to give that to them. So the workers' comp leave may run concurrent with all disability leave. I know we're running out of time, so I don't want to miss the interactive process. It's really important, but I won't spend a lot of time on this slide just to say it can show you, like Linda showed you, that they could all run the same period of time. Just for example, a work-related injury that requires inpatient treatment or that keeps an employee out more than 3 days plus treatment could be a leave that would fall under both workers' comp and FMLA, you know, if it was a work-related injury. Another work-related injury that becomes a chronic serious health condition, you know, smoke inhalation, fumes inhalation, those kinds of things, we see those all the time. You have to consider all of these statutes implications when you have a workers' comp leave as well. Once a workers' compensation claim has been filed, even after the claim period is gone, there may still be potential disability afterwards. There can be, you know, special education disability, and there can be, you know, brain injury that results in disability afterwards. And those of you who have been through workers' compensation claims know that the employees don't always come back. Sometimes the injuries result in leave that results in termination because they are on restricted duties and they can't come back and perform the duties, and then you do terminate them and your workers' comp carrier has to rehabilitate them for another position. So the interactive process, I really misplaced this file, probably should have put this slide after the ADA and the FEHA because that's really where it applies, and this is to assist you in your obligations under both of them. Both the ADA and the FEHA require that you engage in the interactive process to determine whether or not you can provide that reasonable accommodation. So the employer's obligation arises either when the employer requests the leave or some other accommodation, or because the employer becomes aware of it. Maybe not by the employee, maybe by other employees, or just observation sometimes. And the first thing the employer should do is inquire of the need for an accommodation. It's okay in this limited circumstance to ask for medical documentation regarding the need, and most important in this is to prepare a list of the essential functions of the job, and to make a determination with the employee, can you perform these essential functions of the job? If not each one, which ones can you without accommodation, and which ones do you need accommodation? The employer should ask the employee, what types of accommodation are you requesting? If it's just leave, which is what we're talking about here, then can we do without this employee before we jump to the issue of undue hardship? The employee's obligation is to respond timely. We do have, fortunately, case law that says the employer doesn't have to keep chasing for the information. If the employee doesn't respond, then the employer can make the determination based on the information the employer does have. And then once the employee does respond, the employer's obligation doesn't end there. If it is apparent that additional information is needed, the employer must request again. It's an ongoing effort. In fact, interactive means discussion. It's a process back and forth of discussion. Lyndon and I had a little chuckle when we talked about how employers are resistant to this, and she said, yeah, I find it funny that they just don't want to talk because that's all it is. And if you do it, it protects the employer. It provides the employer protection when you go to the last bullet item, which is general steps and documentation. That's when you make your decision, is it reasonable, and you make your decision, is there an undue hardship, and you take the steps necessary to allow the leave or not allow the leave. I think that's my last slide. I will now turn it back over to Julie.
Yes, thank you very much, ladies. As always, information-packed webinar. Linda and Marla, you helped us navigate the leaves of absence. Now, can you help us also navigate some of the questions our attendees have? Let me just go through that one more time. There is a section on your dashboard of your webinar software that says questions. Just click that, type in your question, and I will read it aloud for either Linda, Marla, or both to answer. Linda, while we're doing that, I got an email question from Marta asking if you could just go over that separation form. You said something about leaving today, and you should check that, and then there were some things that you needed to include with that. Can you go back over that?
Yeah, absolutely. So let's talk about the documents that you're required to give somebody. So most companies are going to use a request for leave of absence form. The employees are going to come to them and say, I need a leave of absence, and you're going to have them fill out a form. Just again, with the caveat, just keep in the back of your mind, it can be a verbal request that triggers the leave, but no harm in asking them to fill out a form, right? Just don't require it or deny the leave based on the fact they didn't fill out the form. So most companies are going to use a request for leave of absence form. You're going to take a look at that, and then you're going to make a determination what leaves, if any, is the employee eligible to take, and it may be multiple leaves. So again, in the case of pregnancy, it may also trigger FMLA. In the case of workers' comp, it may trigger FMLA, CFRA, you know, whatever types, right? So you're going to designate the leave. You can use a form for that. You can use a letter. You can use pretty much any format you'd like, but you're going to go through and think about their rights and their responsibilities and go through and designate the leave and let them know we're going to count this against your, you know, FMLA, for example, allowance. So that's it. The day they actually go out on leave of absence, you're going to give them the notice to employee as to change in relationship form. This is a document you should also be giving all of your employees when they actually separate from the company. So it's the document that has the employer's information, the employee's information on it, and then it says on this date this action was taken. So usually you're using it for termination or, you know, layoff or resignation or whatever. It should also be used in a case of a leave of absence. So just think of it as the person is leaving today, leaving our company today for the reason for leave of absence. You're also going to give them the DE 2320 pamphlet, which is called For Your Benefit. You can download that, just Google it, DE 2320. It's an Employment Development Department pamphlet, and it talks about unemployment insurance, disability, paid family leave. So you're going to give them that as well. And then in the case of pregnancy, there's Notice A and Notice B, and you give them one depending on if you have under 50 employees or 50 or more employees. So those are the forms that you're required to give somebody. You, of course, can give them other forms as well. You want to, again, just spell out for them, just think about all the questions they're going to have. How does this affect my benefits? Am I requiring them to use, you know, sick, vacation, PTO? Are they allowed to use it if they want it? You know, all of those different things, and just put it in some written format to them so you capture all of that.
Great. Marla, did you want to weigh in at all?
I think I want to weigh in on what I hope is the obvious. There's a lot of forms, and there's a lot of information that should be included in those forms, in different forms for different types of leave, some forms for all of them. Get some help. Get some help from either Linda or me or some other attorney or HR consultant, and have someone come in. Once you have them in front of you, and Linda does a wonderful job of sorting them for you in folders and easy ways to access them. That, I think it makes it easier. Although a lot of times we still get calls, like I said, and we still pull out our books every time and go through just to make sure we're covering every potential statute.
Great. Vanessa had a question here, just a real quick one regarding requiring employees take sick time but not vacation or PTO. What if PTO and sick time are collectively in one PTO bank?
Yeah, that's going to be a good question from Marla, I have a feeling. But if they're going to be combined, then I think you have to be really careful about requiring the use of it at all, because you're going to have to play by both of those sets of rules. And in the case of FMLA, as an example, it's going to be inherently contradictory, right? So I don't know if there's any case law on that, Marla, or if you even know off the top of your head.
I don't know of any case law, but the rule of thumb on all laws and state and feds is that you always defer to the one that's the most in favor of the employee. And in that case, it would be, well, if it isn't allowed for part of it, it's not going to be allowed for all of it. So Linda's right on.
Okay, great, thank you. Yvonne had a question here. You mentioned private employer, read the FMLA covered employers. Does that also include nonprofit employers?
Yes.
Okay. 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 And Doris, just wanted to clarify here again, FMLA covered employer criteria. Is it 50 employees or 50 full-time employees?
It's 50 employees, and hold on a second, because I think I have in my notes the definition. Again, it's a little bit complicated. So this is what I have in my notes. Any full-time or part-time employee whose name appears on payroll in a calendar week is considered to be employed each working day of that week, whether or not he or she receives compensation. Employees on a leave are counted as long as the employer has a reasonable expectation that the employee will later return to active employment.
Okay.
How's that for being specific, Doris? So again, that's why I said, be careful what you ask, right? That's why I said, if you, that's a great question, because a lot of people may have part-time employees. So if you have temps, if you have seasonal workers, if you have part-time, full-time, all of that, and you're questioning whether or not you are hitting that 50 mark, you want to be that specific in your definition, and you want to take a look at that level of detail to make sure you're getting it right. Okay, so you can Google that. You can, call me or Marla or something, and we can pull up the regs and help you decipher that. But yes, the answer to your question is full-time and part-time.
Okay, great. Okay, Fulla has a question here. Do we send the doctor a fitness for duty letter or job description to determine if the employee can come back and continue the job task? Or, is that an option to terminate the employee if they can't do those requirements of the job?
Fulla, hey Fulla. Yeah, here's what I'm going to say to that. So this is definitely, anytime you're thinking about not bringing somebody back to work, that's when you want to get an attorney involved. And I would say you don't want to send it to the doctor. You want the employee to take it to the doctor. So how I would say it is, I would put in that initial designation notice to the employee that one of the requirements is that in order for them to return to work, they need to bring a doctor's release saying that they are fit to return to work, and you're going to want to attach a job description or the essential job function so the doctor has something to go off of. A lot of times you can do that up front, but obviously you're in communication with the employee throughout their leave. So again, let's take pregnancy. They're going to be gone for a long period of time because they're going to baby bond or whatever the case is. And then when they're getting ready to come back, like you might have a requirement they give you so much notice before they return back to work, so you can look around and see, do we have a job for them? Yes, no, what job, all that sort of stuff. You're going to have them bring a fitness for duty release back to you. Okay, so I would say it that way, Fulla. You don't want to contact the doctor. There's a lot of restrictions around you talking to an employee's doctor these days. So I would request the employee to go get that doctor certification, both up front to say that they need the leave, and then also the release to return to work.
Okay, great. There's time for one real quick question. Oh, Marla, did you have anything
Julie,
you want to add?
Yeah, I did. I just wanted to add to that. Thank you for asking. I did want to add to that. And if we lose the last question, please just send it offline. To Linda's point about talking to an attorney, and then also giving her example of, for example, under PDL, the answer might be different depending on what type of leave you're talking about, and the reason for the leave of absence. So that's really critical to look at because, for example, if you have a workers' comp leave and you have their doctor's note coming back and your claims adjuster telling you, we've already received fitness for duty, they're okay, you're not going to do anything further. You don't want to potentially take that adverse action that's going to result in that 132A action. So you need to look at what type of leave were they out on, and it could be all of them, as we showed, before you just make that decision.
Okay, great. Thank you. And we have a ton of questions, and I appreciate all of your input, but we are going to have to wrap it up right now. Again, on behalf of Linda Duffy with Ethos Human Capital Solutions and Marla Merritt-Robinson with Merritt-Robinson, Jackson, and Clarkson, I'd like to thank all of you for attending today. One of our wonderful attendees did remind me to mention the fact that this session has been recorded and that we're also going to be putting it up on YouTube. So it usually takes a little bit of time to cook the webinar, if you will. But look for it tomorrow. I'll send an email out notifying you when it's available up on YouTube, as well as all the other webinars that Linda and Marla have done along with their guests. Linda, I was wondering if you would close us out, talk a little bit about the next webinar and maybe even the one coming up in April.
Yeah, absolutely. Thanks. So as I mentioned earlier, we're going to do the second half of our Leave of Absence series on March 24th at 11 a.m. In your handout there, you see the link to register, so it's already up and you can register today if you want to, so we encourage you to do that. That's when we're going to be talking about all the rest of the leaves that employers are subject to in California, what's required, what's not, what are some of the best practices, you know, bereavement leave and jury duty and military service and everything else. If you have any questions that did not get answered today, feel free to email me or Marla directly. And I know Julie always provides us with a list of those because the system, GoToWebinar, captures those for us. So if you've already asked the question, don't worry, we're going to get it and we're happy to respond. But feel free to email either one of us. We'll do our best to get you a quick answer. In April, and Julie, do you know the date off the top of your head? I don't have access to the calendar. In April, we're going to have Lawrence Hartley joining us again. For those of you that have heard him before, he's a great speaker. He is super duper knowledgeable about the ACA and compliance with that, and there's been so many changes and postponements and you know, what notices are required and when are we going to need them and, you know, what's the eligibility now under ACA depending on what size employer you are and all that. And he's going to be here in April to just sort of bring everybody up to speed and answer questions about ACA.
Right, and that'll be April 21st, Linda.
21st at 11 a.m. So we'll get you the link to that soon, but April 21st, so go ahead and mark your calendar for that now. And thanks, everybody, for joining us today.
And thank you very much. And just to tag on what Linda was saying, we are starting to cap these out at 100. So please make sure you register early so you do have your spot reserved to attend these webinars. And again, we appreciate your time today, and we look forward to providing you with more useful information in the future. Thanks again for joining us today.